Welcome to EB Spoke, the podcast, Episode 9, Patent Pending. Back in Episode 3 of my podcast, I sat down with John Ruzick and we explored the wide world of 3D printing. It was a great conversation, and if 3D printers are your thing, you should give it a listen. But if you're also paying attention to the world of 3D printers now, you may have heard the news back in August. Stratasys, one of the makers of 3D printer technology, sued Bamboo Lab, a very popular consumer 3D printer brand, for patent infringement. Stratasys claims they have the patents on many key features of printers, such as heated platforms, purge towers, networking features, and more. If Stratasys ultimately wins their lawsuit, any company making or selling printers with those features will either have to stop or pay a licensing fee to Stratasys, if Stratasys is willing, to keep that business going. Plus, Bamboo Lab could be on the hook for a large payment for all the business they did already. While we don't know how this particular court case will play out and the impact on the world of 3D printing, what this case does demonstrate is patents are a powerful legal protection for your invention. If you can stop someone from selling their product because it's actually your invention, that's a lot of economic power. Our guest today is Jon Hobbs, an Atlanta-based patent lawyer. As we dive into today's conversation, we talk about that power and also the value the patent brings to your company as well. For any startups or established companies, understanding that patents around your business can make the difference between success or a sudden end. Let's dive in, and remember, no legal advice is given during this podcast. You should seek out an attorney to help answer any specific questions about your situation. So welcome, Jon Hobbs. We're going to have an interesting conversation today, talk a lot about some of the patents as it relates to software and technology. So maybe let's just kick things off with introduce yourself to us, Jon.
Sure. Jon Hobbs. I'm the director of IP Solution.online. We're a local Atlanta-based firm and mainly focused in software patents. So applying for and prosecuting software patents through the U.S. Patent Office for local clients, a lot of local clients and some clients abroad. And I've been doing this for a couple of decades now. And so we're just excited to be here, and thank you so much for having me on the podcast. Been looking forward to this.
Likewise, before we dive too deep into patents, I know one thing, most people who aren't intellectual property lawyers, who aren't deeply involved with this, probably don't have a clear definition between copyrights, patents, trademarks, and other types of intellectual property. Could you give us like a 30-second different what we're talking about today?
Right. Well, there's 3 different types of patents, actually. So what most people know of, and when you say the word patent, they're thinking of utility patent. And the utility patent is an invention, right? So you create a new widget, and the widget, you want to sell it at Walmart, so you go get a patent for it. But there's also design patents, and that protects the ornamental design of something. So when you think of a design patent, you would think of the famous shape of the Coke bottle, right? Yeah. So that's a great thing for a business to protect because that's part of their branding. And if you produce that Coke bottle, people know the look and the feel of that Coke bottle, and they know they're drinking Coke when they grab that bottle. There's also plant patents, and that's a really specific area, and it's mainly for breeding different types of plants. Yeah. So then trademarks and copyrights, right? A copyright is protecting a creative work. So whenever you write a piece of music or a poem, you're instantly granted a copyright, actually. But being able to sue someone else for using your poem or your song, you actually have to register that. A trademark protects the brand of your logo. When you've created your name and your logo to go with your business, you'd want to get that trademark. So that's kind of the 20,000 feet view of the different areas of intellectual property.
Yeah, exactly. And as we dive into the value of patents and why you should pursue them and why you should understand them, probably the other tidbit to add is that each of those has a different type of protection too, right? Trademarks are perpetual as long as it's in use. Copyright is life of author plus
10 years.
And so, whereas patents, on the other hand, are
20 years. That's for utility design. They're only 15 years. So,
yeah. And so I think we'll get into why those nuances matter as we dive into detail. I wanted to give some framework of what we're talking about because the average business person, they might use those words interchangeably or not understand that the different types of protections that each brings. Coke bottle is a great example because design patent at one point, but if it only had a lifespan, I'm pretty sure they have a trademark around that design as well.
Mm-hmm.
And that's still protected. Right. So yeah, balance those different concerns.
Mm-hmm.
So enough law school lecture. Let's dive into what we want to talk about today. there is the idea of a software patent, right? And the concept of what it means to patent software. So maybe dive into that a little bit.
Sure. Most people think of when they think of getting a patent, they're not thinking about software patents, but it is an area in which people can obtain patents on their inventions. And it's become increasingly important area because the new businesses that are coming out are software businesses. I mean, think about all the solutions when you look at companies like Salesforce, right? Or Google. Google's a software company. Their revenues from advertising, but it's a software company. So the venture capitalists and the banks, they want to fund those businesses because they're scalable, right? So you could have a small group of employees, 10, 20 employees running a company that's worldwide. So there's real scalability and there's real profitability in those businesses. But what I struggle with is educating software developers and businesses about software patents. So they think, lawyer, expensive, no thanks. Where they don't realize that the return on investment is incredible with patents, right? So the average sale price of a U.S. patent is $370,000. That means half of the sales are higher than $370,000.
Yeah.
It's definitely doesn't cost $370,000 to get a patent. Right? I get you a patent for around $10,000. You're looking at a 10x for your investment, right? So it's pretty simple. It's an easy decision when you look at it from that perspective, but a lot of people just don't understand it. And one of the primary misconceptions that I run into is that you're patenting your code.
True. Exactly.
Right? People think, well, I don't patent my code because my code's going to change. We're still iterating versions of it, how we're going to complete these objectives. We don't want to patent it because we just don't know what it's going to look like. You do not patent the code. There is no code. There's no compulsion to produce the code. You don't have to publish the code. No, none of that is true. What you patent is the method of using the software, the use of the software. So think of it as a series of steps in which a script operates on a computer. So say your software receives data from some database. So that's a step. Then your software performs some function on that data, and then it sends it to someplace else. So these are a series of steps that take place that are patentable steps.
It's almost like the machine that the original patents, there was a machine that they were describing. Now this machine is just software and code.
Right, exactly. And there's so much effort and time and money that's put in a piece of software, especially a really good piece of software. You don't even know you're using it because it's so streamlined. It's so easy. It's so simple. And that takes effort. That takes an extraordinary amount of effort and skill for someone to invent something like that. Yeah. Just like anything else in life, there is an optimal way. There's an optimal method of carrying out a series of steps on a computer to make something happen. And that usually results in, for your industry, better protection from a cybersecurity breach, or utilizing artificial intelligence to protect a computer from a breach. You see where I'm going?
Exactly.
You know, that there's different methods that people are utilizing, and there's a lot of companies out there right now doing this and getting patents on these things, these methods of, especially artificial intelligence right now. It's all the rage. It's relatively new to the patent world. So there's a lot of ground to be patented right now.
Yeah.
Artificial intelligence and cybersecurity, especially.
I do have some questions about the AI side of things, but before we get right into that, you can't have a podcast today without talking about AI. That's just a requirement. We've checked that box.
Right. You're not allowed.
There's some interesting nuances there, but I think I want to keep it at the business from a value perspective. So as you were saying before, the patent is not on the code. It's on the process or the method or the mechanism. A famous patent in the early days of the .com was Amazon's one-click patent. To your point, it wasn't the code that Amazon wrote that was patented. It was if you had that mechanism in your website where someone could click one button and have a product shipped to them, you could no longer do that because Amazon had patented that method for that process. And so it didn't matter how you coded it. It didn't matter what it looked like. It was not the manifestation, the actual thing that you built. It was the method.
Right. It's the method. Being able to, exactly what you said in one click and you have something delivered to your door.
And that rippled throughout the e-commerce world because the companies were like, of course we can have one-click order. Like it's technically not complicated. It's very good from a consumer perspective. And so the fact that Amazon got the patent on it and the rest of the world had to suddenly stop thinking about it, stop doing it if they were, I think brings up
Mhm.
Yeah, the other angle of patents, you talked about that patent has a dollar value that you could sell later, but it also has a
Exactly.
competitive value in that you can force your competitors to stop doing something. So maybe going from there.
Right, right. Yeah. The patent is actually an extraordinary powerful instrument, right? You can ban your competitors from importing even the other parts. Say they're building a widget. You can force your competitors from not being able to even import parts into the US through the International Trade Commission. So it's extremely powerful instrument. It gives you the right for 20 years to make, sell, and use your idea. So manufacturing, the use of it. So it is an extremely powerful
Yeah.
instrument.
When I think you and I both will talk to startups frequently. And one of the things that I think hearing about a new startup idea is that's a great idea. If somebody else has already had that idea and patented it, what is the impact of that startup? What do they need to be doing? Call you at that point. Maybe walk us through a little bit of, I've got this brilliant idea. Has somebody else already invented it?
Yes, yes. So that's what a lot of startup CEOs, a lot of startup founders that I talk to, they have their idea, they're ready, they're extremely motivated people. They want to get this product manufactured and they sort of have blinders on. They're moving forward full steam ahead and they don't want to take the blinders off and think, oh, well, I might not be legally allowed this widget. And because there's an expense associated with it, they need to come to someone like me and say, hey, can you look and see if there's anything out there? Do I have the scope, the freedom to operate in this space? So that's a tough conversation to have with these people, with the founders, because they're extremely motivated. They're getting up at 5 a.m. every day, working till 10 at night on their idea. They want to keep the blinders on.
Exactly.
But there's such a thing as infringement.
Yep.
And if somebody's already out there, they've got a patent on this piece of software. And wouldn't you want to know before you drop your life savings into your business and spend 2 years of your life trying to create a piece of software that somebody else has already created and it's got a patent on it? And you're going to get sued for infringement, even if it's not willful.
All right.
Even if you didn't willfully infringe, you can still be sued.
Yeah. I
Right?
think infringement is not just now I have to stop building my product, but I might actually have to pay money to them as well.
A very new case last May. There was a federal jury in Delaware that ordered Microsoft to pay a company called IPA $242 million
Wow.
for infringement of one of IPA's patents on voice recognition software that Microsoft's been infringing on. So even if you're not willful, even if you didn't know that someone else has a patent on this, it's not an excuse, right? You can't say, well, I didn't know.
Yeah.
You're still going to have to pay, right? So it's important to do the investigation first. Let's talk about what your freedom to operate and get that out of the way and then get the patents filed.
So what I think is interesting is what we're talking about is a risk to business. That's a lot of what I deal with is cybersecurity risk, but here it's legal intellectual property risk. The other side of that is actually an asset, right? So if I have this brilliant idea that I want to bring to market, you and I chat and you're like, nope, there's no patents that they're going to prevent you. Well, that's good because now I can move forward. But also if I can get the patent on it, then I've also created this additional asset. So it's like, not only are you creating peace of mind and reducing risk, but you're actually creating additional value to the business that didn't exist until you went through those steps.
Right, exactly. So one average startup that has a patent is going to raise 10x the amount from a venture capitalist. When they go to a VC and they present, they do their pitch and they say, oh, we already have this patented. On average, those companies raise 10x the amount of companies that do not have any intellectual property because it's an unknown. VC, banks, they want to mitigate all the unknown. What are the unknown?
They're risk managers.
Yeah, they are risk managers. I mean, they have due diligence to do for their customers, right? Someone's given them money to loan out to make good investments. It's their responsibility. They've got to make up the 5%, the 10% return to keep their job. So this is the thing that a lot of founders don't even consider. I go to pitches, I hear the VC say, so what's the moat? That's the question I hear. It's the 3 words, or the 4 words. What's the moat? How are you keeping out competitors? So how are you preventing other people from, if I had $200,000 and I wanted to create this piece of software, can I do it? And can I take all your customers from you? What's preventing them?
Exactly.
And in the case of a patent, it's the federal government. So you can't prevent anybody from using, making, or selling your software. So ideally, you want to do the investigation first. You want to look and see, do I have the freedom to operate? And then you want to file the patents as soon as possible, because there's what's called a statutory ban. Anything that's in public use is statutorily banned from being patented. You're only able to obtain a patent for something that is unknown. It has to be new. That's 101. That's the basics of patent. If you're a founder, you go out there and you put your SaaS platform up and you've got customers on, you're banned. You can't obtain any patent for that.
You have to come up with something new. And you mentioned earlier that it's that expensive to get a patent, but so far we talked about Amazon, we talked about IPA, we talked about Microsoft, who has a ton of patents. I think people, when they hear patents, they think of large corporations getting these patents because it's just part of normal business operation. $10,000 to them is pennies. Who else is filing software patents? Big companies, small companies, like who is doing this?
Yeah. So just to give you an idea, especially in cybersecurity is a very hot area, of course. So in 2020, IBM received over 9,000 software related patents. And about 1,400 of those were cybersecurity related. So you say 2020, that's kind of old news. Well, there's a lag. Everything is confidential when you file a patent. It's not known to the public. When I file a patent on behalf of my client, that is still confidential until it's been at least reviewed by the patent office. And then there's a publication date that's set, and that's 18 months from the time of usually the filing. So there's another year and a half lag. In order to collect really good statistics, you got to go out a few years at least. But IBM is a big player. I think also anyone, that includes any person or entity in any other country, is also capable, allowed to file a patent in the US. So founders in the US they're competing with other founders here, but abroad too. Anyone in the world could file a patent in the US. To give you another example, China Electronic Technology Cybersecurity Company filed 135 cybersecurity related patents between 2020 and 2022. It could also potentially be banned from doing your business by a company that's outside the U.S. So it's another thing that founders need to think about, is that they're competing worldwide.
If we're patenting for the purpose of prohibiting use, as opposed to ourselves going out and bringing it to market in the cybersecurity, that could get really awkward, right? Like a criminal could patent a technology that makes, if they prevent people from developing that technology, their jobs are easier, right? And I'm sure there's a criminal probably can't get a patent, but a non-criminal could, right? So
Yes, that's absolutely true. If you want to prevent other people from utilizing artificial intelligence to attack something, intentionally do that.
They would have already thought of it too. You mentioned other countries. Maybe I know the question that comes up frequently with patents is, I get something, if I have a patent in the US and then I want to expand my market to Europe, what's that kind of interplay internationally?
Sure. So there's a few different routes you can go if you're trying to file patents in other countries. PCT is one route, and there's contracting states in the European Union where you can file just one patent and it's covered through most of the countries in Europe. So it's a little more streamlined process in Europe, but in Asia and the Middle East, you just have to apply in each of those countries.
Okay.
Like if I wanted to file a patent in Japan, for example, I just have to deal with an attorney in Japan. So the good thing is most of the laws are pretty compatible in terms of our agreements with other countries and how we execute the prosecution process and also the litigation process. And so you're not going to face major barriers when you go to do the prosecution and litigation in other countries, because the process was fairly similar.
Okay.
So that's not a problem. It's the expense. And so then that boils down to a business decision. Is my market going to be Japan? And that's something you just have to discuss. And it's all about the return. Your investment is going to be prosecution in that country, and it could be $20,000 or something. I don't know. Depends on which country. And then, are you going to get that on return? Or do you have commercialization strategy? Do you have branch office set up in that country? It's a business decision after that. But most of the startups, dealing with a lot of startups and smaller companies, so they have no consideration for another country. And the U.S. market is an extraordinary market too. Right. If you can win here, then you're going to be doing well.
Absolutely. So I'm curious, you mentioned earlier that it takes 18 months for that to even become visible, right? From a research perspective, but a company needs to be thinking, I have something that may be patentable. I'm developing it. Maybe I'm launching a product. Walk me through the timeline. I've come up with this new idea. I start to build it. I launch to the market. And then, because it could be years before I get that patent, but when do I need to start from a timeline perspective?
Yeah, before you launch, I would not publicize anything until we've had a talk. The reason why people start business is because they think, well, I can do that better. Why isn't this solution out there? So within that idea, why isn't it this way? That's what's patentable. You don't have to have the product done and perfect. And no, that's not required. There is a requirement for, producing the invention, but you can do that later. It doesn't have to be upfront. So really before launch is the best time. Let's talk through why the patentability of that solution was in that eureka moment. We just have to tease it out and protect it.
Yeah. And if I go to market, I remember something about there's a timeline where I think you even mentioned earlier, things that are public can't be patented because they're not new. If my idea has been in the market 5 years, is it new? Can I come to you then?
Yeah. So there is a grace period. So if you do go public with your idea, you have a year grace period.
Okay.
That you can apply.
So not that long.
Yeah. That you can apply for a patent within that period, that 1 year period. So the other thing is there's also what's called a provisional patent.
Okay. Yeah. I was going to ask about that.
Yeah. And so those are, if you're really not sure about how your solution is going to unfold or how you're going to build your solution, then you can file a provisional patent. It's less expensive to file. The requirement aren't as high because it's a provisional and it's basically a placeholder. So you file this basic description of your invention and you have 1 year. It gives you a 1 year period before you have to actually file the full utility patent. So a utility patent, the important part of the patent is the claims, which are the legal language that describe exactly what your invention is. And that's when I argue with the USPTO on your behalf. That's what we're arguing about for the claims. So in a provisional patent, you're not forced to claim anything. You don't have to claim anything. But the utility would file the regular patent, write out those claims.
I've known several startups who have gone that provisional patent route, start the process, but they're not ready to commit the full dollar amount or the full raise. Another kind of curiosity there is sometimes you'll go to a website or a product and they'll, the patent number bottom. So they're advertising that they have patents. Do they have to? Do you have guidance?
Yeah, it's definitely bragging rights, but also you want to let your competitors know too, right? That you are actively pursuing intellectual property and make them aware that they could be sued if they're trying to copy your website, trying to copy your software solution. Definitely. As soon as you apply for a patent, you'll be given an application number and you can list that application number and say patent pending, right? So your protection starts at that point when you file the application, right? You can go back once the patent grants, you can go back and sue people from that date of the application for infringement. So it's important to list that. The investors want to know too, right?
Of course.
Let the investors know that you're actively pursuing patent protection, and it's good all around to let people know. And typically you're going to list that on the product too. There's some stipulations surrounding it, but with software, it's a little different, right?
In the about page down at the bottom,
right?
The section of all the patents, right?
Right.
The other aspect of that, you mentioned sue people back to the application date. Well, what if my client before the application date using that same idea, they didn't patent it. They just said, we don't care about patents. And now their competitor, same idea, got the patent, but the actual use happened before. Because I think timing matters there too, right?
That's tricky because the patent office, when they do their discovery, they're supposed to find that stuff. They're supposed to find any other it's called prior art, any other instance of that invention that may exist prior to your application. Well, once a patent's granted, it's granted, right? We assume that there's never anything that existed like that after it's granted because the patent office did the research. So in that case, you would still be able to sue for infringement. This company says, they say that they were in use before you got the patent. It doesn't matter because the patent office didn't discover it. So, because people can say anything, right? We were doing this 10 years. Well, if you were doing this 5 years before us, then why didn't you have a patent?
Which just reinforces the importance of the patent, of having the conversations, right? As it's not later.
Exactly.
So we mentioned AI and the patents, and I think that's a super interesting thing today because so many companies are launching products based on AI, but often those are not their AI, right? They are reusing the LLMs developed by some of the major AI companies or some of the research done, academically.
Yes.
And so I think I'm curious is if I build a product today that does some amazing thing and it leverages OpenAI's APIs, well, I haven't really invented the AI. I've invented the use of the AI, perhaps. I have a new way to think about this particular problem with that AI. So I'm curious if you have thoughts on that or where, if somebody has an idea, they should talk to you and they should come to you and for it in the context of a proper conversation, but casually amongst friends. I think it could be messy, is my unofficial opinion.
Yeah, and I love that you brought this up because AI is my specialty. So I am applying for patents on behalf of clients utilizing artificial intelligence. They may be using an API from ChatGPT or any other source. It doesn't matter. As long as they've come up with a new useful solution utilizing AI, it doesn't matter. They don't have to invent the AI. They don't have to even improve the AI. Their invention would be directed towards solving some other problem with AI. AI is a tool that's to be used to design a new piece of furniture. You can utilize artificial intelligence to do something like that and get a pen. Now you have to make a significant contribution to that design. Now that could be you formulate the type of wood that the artificial intelligence uses to design the furniture. So that would be a significant contribution. Maybe you discovered you had to design this chair, and I designed a type of chair for you. But when you sat on the chair, it collapsed. Well, you had to figure out a way to put reinforcing dowel rods inside one of the legs. Now that is a way that you can get to utilize artificial intelligence to design furniture. And that's just one example. The Patent and Trademark Office just produced guidance, some new rules for practitioners with the utilization of AI. So there's a couple of those. So one example is utilizing artificial intelligence to design a new transmission for a car. So if somebody goes to ChatGPT and says, hey, I've got a 350 Chevy engine. I want to design a new 18-speed transmission for this Chevy. They feed it some training data of all the transmissions that are available presently. And they say, of those transmissions, of all the 330 transmissions that I've trained you on, design a new one that's more efficient or something like that. So this is one of the examples that the USPTO gave to us recently. And
Can I ask a question about that?
sure.
So is the patent on the use of AI to design a transmission, or is it on the new transmission that has been invented by the AI, or both?
It depends. It can be both. If you're utilizing, so say you've figured out that if you tell the AI to focus on certain parameters, for example, that can be part of the patentable subject matter, right? Because
Right.
you've figured out, well, I can kind of focus on this area and I get this result from that. So that's one of the areas that, yes, I want to try to get patent protection for my clients, right?
Yeah.
And also be in how you train it, right? So I'm getting method patents for clients on how they train their AI, right? So I want to claim how the method of how I'm training my artificial intelligence. That's also patent, right? So then you're preventing other people from even being able to train in the same way that you're doing.
Sure.
Does that make sense?
Yeah, it does. And I think that at some point AI is going to be actually the one inventing things, right? And so we'll have to figure out, can you patent a new idea if it came purely from an AI? Just like we have that same question on copyright and other things like, does the AI produce copyrightable material when it writes my copyright? I think we'll have those same questions on the patent side once the AIs get a little more creative.
Sure.
But in the meantime, the AI itself is, and the mechanism of using it, right, at least is.
Yes. Yeah. You can't get a patent for an invention from an AI.
Right.
You have to make that significant contribution. You have to be able to show the USPTO, or we have to, that you have some sweat equity in there. But what it boils down to is I've had to really do some experiments. Okay, the AI produced this model, but the model failed. And so we had to go back through. And the reason why it failed was because the model predicted that we could do this with wood, but we have to use stainless steel, right? So we figured that out through experimentation. We went through 6 iterations of different materials. We found out that this certain combination produced a brass metal that could do this. And we did it. So that's that sweat equity. And that's the significant contribution that the USPTO is looking for, for patentability, right? They want to encourage people to use artificial intelligence, right? That's where this is going. You want all the potential aids, whatever advantage that you can use to create something, create a new innovation. And you want all those advantages.
If there was a theme here, it was reach out early, reach out often, right? As you have these ideas to figure out where you need to go next. So if somebody does want to reach out, how are they getting in touch with you? What's the best way to get in contact with you?
So check the website. You can contact me and book a consultation there. It's www.ipsolution.online. So that's IP is intellectual property solution. It's not internet protocol.
Exactly.
So there's a little technical difference there. Yeah. So there's on the contact page, you can book a consultation with me.
And your
So-
focus is software, it's AI, it's that type of patent. So if I invent a better mousetrap, should I contact you as well? Or is it just for the
Absolutely. Yeah. I work in a lot of different areas. So in mechanical or robotics and biomedical stuff, work in a lot of different areas, but AI software, AI implementation into software right now is a hot area. So
yeah. What is that one thing that people should just take home today?
that you want to know, right? You have a great idea, but can you execute on that idea without infringement problems? I'm here to act as an advisor and reach out. I'd love to help you guys.
Awesome. I appreciate you joining me today. I think there's no shortage of things we could talk about, especially once the topic of AI gets opened up. I'm glad you spent some time with me this morning and enjoyed the conversation. Thanks for listening to EB Spoke, the podcast. This podcast was produced by Erik Boemanns, founder of the fractional CTO and CISO firm Mirability, and features a wide variety of topics. Keep listening for more topics in the future, including cybersecurity, risk, compliance, and more.